Good morning, dear students. I hope all you are doing very fine. Today, 2nd April is a day of hope. It's an International Hope Day. Actually, every day is a day of hope. And today we are hoping to understand our topic in a much better and concrete way. And this hope will result into good attempt of the exam. And definitely you are going to not only appear but pass your exam with the hope. Not for this day only, but for all of the days. To begin with this hope, to begin with this enthusiasm, the remaining section of Paper 2 Business Law Chapter, Relation of Partners. I hope, students, that you have been covering the previous lessons, the previous sessions throughout all your this previous days, because if there comes across any gap in between the topic, it might trouble you because lag in the studies will result into putting into much effort rather than if you keep on learning. If you keep on learning these subjects on a continuous basis. So let's begin with this quote. Today I am going to begin my session with the statement by APJ Abdul Kalam ji. Dream is not that which you see while sleeping, it is something that does not let you sleep. हम सब ने ये सुना है, जाना है. We have been heard of this statement number of times across social media and all that, but it is true and it is very much apt statement for us being a CA student. So awake and dream. Now coming back to the topic, we have been covered so far in section 13E. It's indemnified. Right to share a remuneration we have completed, right to share profits, interest on capital, interest on advances, and right to be indemnified. Okay, so far we have done this. Now we are going to cover the remaining section of this chapter, and it begins with section 17. Now students, as I told you in the previous classes as well, recalling the section is very much important, not only under the Partnership Act 1932, but every law. So in my PPT, in my study material, I always put section first, and it is in capital letters. So you must be aware, it should be prompt to see that what section it belongs to. So section 17 says rights and duties of partners after the change in the firm. Now the first question arises, sir, what do you mean by change in the firm? As we have already discussed, few instances happen or few things happen and it will result into change in the constitution of firm. Sir, what are those? Number one, when a new partner or partners comes in, it means admission or admissions result in change in the partnership form. Second one, when a partner or partner goes out, it means retirement or retirements or by any other mean, for example, by death. So coming in or going out will result into change in the firm. Third point, where the partnership concerned carries on a business other than the business for which it was originally formed. It simply means if you are into an education sector, you are providing in a healthcare sector, and you're moving vice versa, for example, from health to education or from education to retail or from production to trading, it means basically you are changing the nature of the business. अभी अगर nature of the business change है, it means change in the partnership form भी है. So far 3 points: incoming partner, outgoing partner, change in the nature of business. Sir, what is the fourth point? When the partnership business is carried out on after the expiry of term fixed for the purpose. So the original partnership forms brings a change. So there are 4 instances: incoming, outgoing, change in the business of the firm, and carrying on the business even after the time period fixed for the partnership firm. Is it clear so far? Just let me know immediately. Write it down in the chat box. Hurry up. Good morning. Clear. Okay, fine. Yes. Now, after a change in the form, where a change occurs in the constitution of form, the question arises, what happens when there brings a change in the partnership form? Okay, sir. This is the old partnership form and this is the new partnership form. What are my rights and duties? What were my rights and duties and what are my rights and duties in the new constituted form? So how does it make clear to the partners? So let's understand it over here. Where a change occurs in the constitution of the firm. Now, sir, what do you mean by change in the constitution of firm? It is in a partner if admits, if retirement, if death, if change in the nature of business, or even after the expiry, you keep on doing the same business. So constitution में change आने पर mutual rights and duties of the partners in the reconstituted firm, जो नई firm थी आपकी, this was the old firm and this was the new firm. It remains the same as they were immediately before the change as far as may be. However, we always put however, subject to the contrary. What does it mean if I put one line subject to the contrary, otherwise expressed? What if in this statement I added a line, I put a line, contracted to the contrary, if the terms agreed? What does it mean? Explain me. Yes, Monu Singh, death obviously means a change in the constitution of the firm. If it is agreed by some kind of agreement or negotiation, it will happen that way. Otherwise, the general law says this. Now, second point, after the expiry of the term of the firm, if there is a term fixed for a partnership firm to conduct the business, sir, what happens if the expiry of the term of the firms arrives? Where a firm constituted for a fixed term continues to carry on the business even after the expiry of their term, the mutual rights and duties of the partners remains the same. जैसे कि पिछले पॉइंट में था, as they were before the expiry, so far as they may be consistent with the incident of partnership at will. It should be harmonious. It should be incident to the partnership at will, which was previously held. Now, what is the third point? In case of additional undertaking, say for example, you bring a new adventure or a new project or change in the nature of business, what happens? Obviously, then now it is a new firm. When a new firm constituted to carry out one or more adventure or undertaking carries out other adventure or undertaking are the same as those in respect of original adventure or undertaking. It will go that way. Clear? Section 17 talks about rights and duties in a new form, new reconstituted form. Then it brings three separate points, and in every point we come to know, we understand what are the rights and duties of those partners in the new partnership form, new reconstituted form. Now section 18. Section will go in a series through the entire PPT except for one or two. 17 section के बाद 18 section आता है. It says relation of partners with the third parties. Now it is very important because on one side there are a number of partners, everybody is agent and principal to each other, and on another side of your table is the third party. उसके बारे में उनके साथ आपके रिलेशंस कैसे रहेंगे, आपकी उनकी राइट्स और ड्यूटीज क्या रहेंगे, ये हम सेक्शन 18 डिफाइन करेगा. नाउ सेक्शन 18 क्या कहता है? पार्टनर एजेंट एज एन एजेंट. सर we know this point number of times that partner is an agent to each other as well as principal to each other. Then what is the scope of agency? Agency is limited to the business of the firm only. It means anything which is done in the ordinary course of business makes the partners liable and binding to each other as well as to the partnership firm. It simply means anything done beyond the scope of business of your partnership firm does not bring any kind of agency relationship among the partners. So scope of agency is only for the conduct of business, only for the ordinary course of business. This we have understood number of times. Now, what is the binding effect? Sir, you have already told us action taken by partner within the scope of their agency not outside the scope of your agency, is defined by the act and bind the firm as well as the partners. Now there is a slightly different point, student. Can anybody answer me? For example, there are 7 to 8 partners in a firm. Everybody is agent to the other partner. Any act done by one partner binds the firm within the scope of his agency. So partners are agent to each other in the ordinary course of business, but they are not agent in relation to the personal conduct of their own. It means conduct should be for the business purpose only. बेटा ये लाइन समझना बहुत जरूरी है कि what does business purpose says. I have put in a few examples where at one instance it will comes under the scope of business, and at the other instance the same thing does not comes under the business conduct. I'll be covering that. यानी कि आप ये समझे कि हमने ये तो माना है कि बिजनेस कंडक्ट में ही कोई चीज करनी चाहिए, तभी आप एक दूसरे के लिए लायबल होते हैं, तभी आप एक दूसरे के एजेंट होते हैं. बट देयर आर फ्यू केसेस जब आप सिमिलर चीज करते हुए तो एक कंडक्ट ऑफ बिजनेस नहीं कर रहे हैं, लेकिन दूसरे सिचुएशन में वही काम करते हुए आप कंडक्ट ऑफ बिजनेस माना जाता है. अब इस चीज को ध्यान से सुने, क्योंकि इसको मैंने आगे कवर भी कर रखा है और वहां पर आप मुझे आंसर करेंगे उसको. Essential element हम जानते हैं सर, we have understood it number of times that principle of mutual agency is the core element of partnership, where each partner acts as both principal as well as an agent. Now this is what section 19 is very important. Implied authority. We understand the meaning of implied. One is express and another is implied. What does implied mean? Can anybody tell me? Yes, okay. Implied, what does implied means? Imposed, shown by actions, yes. Miss Kohli Pakka, correct. Chinmay, correct. Non-verbal, yes. Meenu, correct. Yes. Now what happens with the partner if they act in terms of their implied authority? Subject to the provision of section 22. Now sir, what is this section 22? We are on section 19. We are going to cover it right after this. 22. Mode of doing act binding on the form. Okay, we have an example as well. पहले इसको समझे. Subject to the provision of section 22. सर हमने 22 अभी नहीं पढ़ा, तो बेटा अभी पढ़ोगे. अभी इसको देख लेते हैं कि क्या कहता है. The act of a partner which is done to carry on in the usual business of the kind carried on by the firm binds the firm. Sir, this is what we already know. What is the next step? The authority of partner to bind the firm conferred by this section is called implied authority. Sir, this is also we know. In the absence of any usage or custom of trade to the contrary, the implied authority of a partner does not empower him to. Now, why this particular section does not empower him to be imposed in the law? Because implied authority actually don't have any scope. As such, it is illustrative, not conclusive. So it says, if you have done something within the scope of your business for the benefit of business, you can do that in the capacity of a partner as an implied authority. But that does not mean that in the name of implied authority, you can do anything. That is why, to make it more clear, the section itself clarifies what it does not include. Number one, submit a dispute relating to the business of a firm to arbitration. You just cannot submit a dispute to arbitration. It is not at the discretion of one or two or more of the partners. It is not an implied authority. You just cannot open a bank account on your own name. You just cannot say it is my implied authority. Specifically excluded. You understand? These points are specifically excluded, which says that these points are not covered under the scope of implied authority. Third one is you just cannot compromise or relinquishment. You just leave the right. अपना अधिकार छोड़ रहे हैं आप उस पे से. Any claim or portion of the claim by the firm, how can you see these are malified intentions? It is apparent that these could be malified intentions on the part of partners. Withdraw a suit or proceeding filed on behalf of the firm. It cannot be your implied authority. Last E point is admit any liability in a suit or proceeding against the firm. It simply means you just cannot put a case on somebody on behalf of the firm on your own, or you just cannot admit any liability against the firm in the capacity of partner. Acquire immovable property on behalf of firm. Transfer immovable property belonging to the firm and enter into a partnership on behalf of the firm. Now the question is, sir, if partner cannot do these things, there are a number of things. At once you said partner is the agent and he can do anything in the ordinary course of business. Sir, these could be the ordinary course of business. If you are binding the hands of a partner, see, you are putting handcuffs in the hand of partner. You are the section provided for, he just cannot do this, he is not empowered to do this. Then what can a partner do? Let's understand it with the help of an example. अभी सब कुछ तो मना कर दिया, सेक्शन 22 और सेक्शन 19 ने मिलकर सब कुछ मना कर दिया है, तो पार्टनर कर क्या सकता है? Let's understand it. Anurag and Prerna are partners in a paper mill. Anurag borrow money and execute a promissory note in the name of firm without any authority. Now the question arises, are the partners liable? My answer is no. See, I have written it no. I make it edit. Now you tell me, can other part, the Anurag and Prerna could be held liable? Both. Anurag has done something which may or may not be his implied authority. Can anybody answer? We have put on restrictions on Anurag's capacity that he can do this and he cannot do. Execute a promissory note in the name of firm without any authority. Is it possible? Arbitration labonisa means putting it is about deciding about the jurisdiction, okay, where we have decided to put a particular case to a particular authority. For example, you and me decided in a contract that for any if there is any conflict arises, we put our case to this particular jurisdiction. That is called arbitration. No, Anurag's personal liable, it is not partnership liability. If the loan is taken for the business purpose, then why can't the person be bound? No, if the loan is taken for the business purpose, partner would be held liable. Yes, partners are liable for third party, but Prerna recover from Anurag. See, just understand. Listen very carefully. मैंने आपसे पहले कहा था, there are few circumstances, then one thing could be covered under the scope of implied authority, and the same thing would not come under the scope of implied authority. It depends upon the nature of business. In a paper mill, is borrowing money and executing a promissory note is the ordinary course of business? No. So Anurag has not acted in his implied authority. Anurag is liable because first of all, it is without authority. Second one, it is not the ordinary course of business. You understand the nature, the ordinary course of business element, which is an essential element, is not present over here. So the answer is no. Now the question in bold, what would be your answer if the firm operates in banking? Please answer me. Minu, no. The answer is Anurag cannot, then the firm is liable. Monu Singh, why the firm is liable then? See, the situation takes a 360-degree turn. Earlier you held Anurag as responsible. Now you are saying that Anurag is not responsible. ऐसा क्या हुआ कि Anurag responsible अब नहीं? Business is of banking. Yes. Tuti Goenka has correctly answered. It will be in the ordinary course of business, because borrowing money, execute a promissory note, it is in the ordinary course of a banking business. Then Anurag conduct to borrow money and execute a promissory note comes under the implied authority of Anurag. Will also, yes, Laboni Saha has correctly answered that liable as Anurag has acted in the ordinary course of banking business. Because, okay, now you all got the point. So you understand how in a particular situation one is considered to be acted in an implied authority, and in the same condition, because it is in change in the nature of business of the firm, it includes in the implied authority, and it could exclude the implied authority depending upon the nature of business. Now section 22. Let's understand it with the help of an example. Just jump on to the example. Prag, a partner in a firm named Basu Enterprises, borrow money and execute a promissory note in the name of firm without authority of other partners present in issue. The example is similar because the section goes simultaneously, because subject to the provision of section 22, the existence of section 19 was there. The other partners are not liable on the note, as it is not the ordinary business of a solicitor to draw, accept, endorse a negotiable instrument. Student, take note, it may be usual for one partner of the firm or banker to draw, accept, or endorse a bills of exchange in the firm if it is a business of banking. You understand? Now section 22 एक बार पढ़ लेते हैं. Binding on the firm है, ये बात हमने पढ़ ली है. How to bind? The act or instrument must either be done in the firm's name or in any other manner that clearly expresses or implies, या तो वो express कर रहे हैं या implies कर intention to bind the firm. Example, if a partner signs a contract on behalf of the firm, it must be done using the firm name or in a way that clearly indicates the intention to bind the firm. It means for the benefit of partnership firm, not for individual benefit. And mutual agency is always there. उसको बार बार नहीं पढ़ते हैं, ये बात हम जानते हैं that mutual agency exists in the partnership. Now there is journal act done by the partner that could include. अभी देखिए बच्चे, ये कुछ points हैं जो आपका journal conduct है. It means ये आपकी implied authority कहलाएगी. Now don't get confused कि सर implied authority में क्या नहीं आएगा और क्या आएगा. कुछ तो हमने specifically मना कर दिया बेटा. ये sections हैं जो specifically मना करते हैं. इसको देखें. In the absence of any usage or custom of trade, ये चीजें हमने specifically exclude कर दिया. आप नहीं कर सकते. आपको पता होना चाहिए. Exam के point of view से it is very much important. For example, there is a case law given in which a partner comprises or relinquish any claim or portion of claim by the firm. It is given in the form of a statement of XYZ or PQ1. You must be aware that subject to the provision of section 22, there are few conduct which is expressively exclude from the implied authority. So your answer would be no, that the partner could not do this. It cannot be considered as an implied authority. Okay? For example, institute asked in part B that what if it is in a banking business, then your answer would be different. Always write section while answering the question. Institute always ask for the section. It will help you to score good marks. So far we have done section 19 and section 22. 22 में एक चीज रह गई है कि जनरल एक्ट में क्या आता है. He may draw, make, sign, endorse, transfer, negotiate, and procure to be discounted. These are just, you can go through this. These are general conduct of the business if you are in a banking business. He may pledge or sell the partnership property. He may buy goods on account of partnership. He may borrow money, contract debts, and pay debt on account of partnership. लेकिन अभी बेटा इसमें एक बड़ी इंपॉर्टेंट चीज है. If the intention is आप पार्टनरशिप प्रॉपर्टी को प्लेज कर रहे हैं, सेल कर रहे हैं, ठीक है, आप कर रहे हैं. बट इफ द इंटेंशन इज मेलाफाइड, इफ इट इज टू डिसीट द पार्टनर्स, टू conceal the effects from the other partners, and it is not in good faith, then it will not come under the scope of general acts. You understand? It depends upon the case to case. Now section 20. पार्टनर की implied authority क्योंकि बहुत vast है, and there are few things which are not allowed. There are few things which comes under general conduct. So, sir, it creates a very confusion among students. Sir, what comes under the implied authority and what comes outside the implied authority? At one point of time, you are saying that, sir, I can sell the property of a partnership. At another point, you are saying, sir, I cannot do this because it does not come under implied authority. So, it is clear with the help of with the usage of the conditions or terms in an agreement where there are specifically restrictions or there are specifically extension of a partner's implied authority. सेक्शन 20 इस बारे में बात करते हैं, ठीक है। इसको एक बार थोड़ा सा एग्जांपल देखते हैं, फिर बात करते हैं ऊपर की। If just look at the example, if a partner has the implied authority to borrow money for the firm, but the partnership agreement restricts this authority. See, what is the general conduct? You can borrow money for the partnership firm for the smooth conduct of business of the firm. So, sir, borrowing money is under my authority. लेकिन तब क्या होगा if partnership agreement restrict this authority? It means a specific restriction has been put upon. The firm is still bound by the loan taken by their partner unless the lender was aware of this restriction. Please tell me with the help of a case immediately what does this line means. अभी आपने कह दिया सर borrow money की है, within authority की है, of the firm is liable. Outside the liability authority की है, sir you are saying now even the firm is liable. The firm is still bound by the person who has done something which is outside his authority. Still the partnership firm is liable. How? But there is a line, the partner, the lender was aware of this restriction. ऐसा आपने कॉन्ट्रैक्ट एक्ट 1872 में भी पढ़ा, where yes answer. See, the lender who is lending money to you is aware that you are doing something which is not under your authority. पढ़ा आपने कॉन्ट्रैक्ट एक्ट में भी, lender cannot take the plea if this is the case. But what if the lender is aware that the partner is going outside the authority? Then is the firm liable in that case? Just answer me. What happen if the lender? No. Okay. Yes, one is yes and another answer is no. See, lender is aware that you are doing something which is outside your authority. The lender should not lend if he knows the partner goes outside authority. Then who will hold responsible, Stuti? The third person, the lender, is aware that you are doing something outside your authority. The partner only, yes, not the firm. Otherwise, the firm is liable. Stuti has correctly answered. Great. बेटा और आंसर्स नहीं आए. Where is Sharma Vivek, Meenu, Laboni? The partners only. Good. Beta, answer quickly. We don't have this much of time. Okay, so moving on. The partner only. Okay. Laboni Saha, my question is, if a partner is borrowing something, asking for a loan other than his authority, the firm is liable. What happens if the lender, the person who is giving the money, is aware that the partner is asking for loan which is not in his authority? Who will be held responsible in that case? Okay, Stuti has again questioned, the partner is still breaching his implied authority. See, that the section, understand the basic intention of putting a section in the law. It means if partner has done something outside his authority, See, you have understood one is doctrine of indoor management. You understand this concept? The other, see, it is not the duty of the lender to inspect or to inquire into the inside management of the, how it is possible. The lender is not aware whether the particular partner is doing something which is outside his authority. He is not supposed to check all those documents or all his authorities. You understand the doctrine of indoor management? Yes, Lamoni, in that case, only that partner, he, second, just wait, let me check the answer of Laboni. In that case, only that partner will be liable and not the firm. Yes, now you understood, Laboni. He will be personally responsible for the meeting. Okay, now you got this. Okay, moving on to the next point. Hasni, the lender is unaware of this restriction. The firm is liable to pay the loan. Yes. Hasini has correctly answered. Yes. Okay. 23. Effect of admission by a partner. एक एग्जाम्पल पढ़ते हैं बच्चे, फिर समझते हैं. If a partner acting within the scope of partnership business makes a statement about a contract, that the statement can be used as evidence against the firm. एक आगे हमने एक एग्जांपल दिया है. सपोज एक पार्टनर सप्लायर को एक स्टेटमेंट देता है, द पेमेंट इज ऑलवेज मेड विद इन 30 days. This is a statement. It means partner is it. The admission does not here means the incoming partner. It means something to be admitted either orally, verbally, or written by a partner. A partner is making a statement that the payment is always made within 30 days. It is a statement admitted by the partner. And आप ये बात जानते हैं कि जब भी कोई पार्टनर कोई चीज कहता है या करता है, वो फॉर्म को बाइंड करती है. किस उसमें बाइंड करती है, किस प्रिंसिपल पे, फटाफट बताएं बच्चे. पार्टनर कुछ भी कह रहा है या कर रहा है, एनी कंडक्ट इधर वर्बली, ओरल, रिटन और बाय हिज एक्शन बाइंड्स द फॉर्म ऑन विच प्रिंसिपल. जब इंस्टीट्यूट सवाल करता है तो प्रिंसिपल का नाम लिखना पड़ता है कि किस प्रिंसिपल पे बेस्ड आप आंसर कर रहे हो. यस, स्तुति लबोनी, प्रिंसिपल ऑफ म्यूचुअल एजेंसी. ऐसा ही है. सपोज पार्टनर एक स्टेटमेंट देता है दैट सप्लायर हैव नॉट मेड पेमेंट, यूजुअली लेट पेमेंट्स करती है. ये भी उसके अगेंस्ट, ये फर्म के अगेंस्ट स्टेटमेंट यूज की जा सकती है. नाउ व्हाई फर्म के अगेंस्ट स्टेटमेंट तो पार्टनर ने दी है. इफ अ पार्टनर हैज मेड अ स्टेटमेंट, व्हाई इट कैन बी यूज्ड अगेंस्ट दिस स्टेटमेंट? It can be, it will be treated the statement of a firm. Why? Again, why? The same principle. बेटा फटाफट आंसर चीज का. Any statement, anything admitted by a partner, only one partner, even there are number of partners, any statement made by one partner is treated to be the statement made by the firm. On what ground? Repeated so because the principle of mutual, Laboni principle of mutual agency तो ठीक है बेटा. करेक्ट लाइन बताओ. एजेंट भी ठीक है, सारा ठीक है. एग्जैक्ट लाइन चाहिए मुझे बेटा, बिकॉज आंसर मस्ट बी कंक्रीट. आई ऑलवेज सेज you don't have to put into the stories in your answer sheets. The correct usage of he binds the other partners, still not the concrete answer. Stuti Goenka, however, is just close to the correct answer, binds the other partners. आपने वो लाइन आप भूल गए हैं. डन बाय वन और ऑल, एक्टिंग फॉर ऑल, ये भूल गए आप लाइन. ठीक है, एक्टिंग फॉर ऑल यानी कि अगर एक पार्टनर एक स्टेटमेंट दे रहा है तो वो एक्टिंग फॉर ऑल कर रहा है. ठीक है, समझ गए. ये सेक्शन यही कहता है बच्चे. इसको ज्यादा हम उलझते नहीं कि इसको ये क्या कहना चाह रहे हैं. बाइंडिंग इफेक्ट आपको समझ आ गया. इफ एनीथिंग, एनी स्टेटमेंट रिटन, ओरल, बाय एक्शन एडमिटेड बाय अ पार्टनर, इट विल बी ट्रीटेड एज द स्टेटमेंट मेड बाय द फर्म. बात खत्म. एग्जाम्पल से हमने समझ लिया. एक एक्सेप्शन जुड़ गई बेटा. स्टेटमेंट मेड बिफोर बिकमिंग अ पार्टनर. Now you're going to become a partner within few minutes or within few hours or within few days. But you have made a statement and the third party relies on this statement. However, when the statement was made, You are not the partner of that partnership firm. Will it be treated as an evidence against the firm, or will it be treated as a statement made by the firm? No. Obviously, because you have made a statement not in the capacity of a partner, in the capacity of a person only, bind the other. No, acting for all, acting. Meeno Kumari ने सही जवाब दिया, acting for all, any of them acting for all. Correct. Okay, okay. Got your points. Moving on to the next point. Effect of notice to acting partner. बेटा इसमें भी ज्यादा नहीं पढ़ते, just jump onto the example. If a partner who manages the firm's finances received a notice regarding a loan repayment, यानी कि एक पार्टनर कोई एक चीज देख रहा है, फर्म में कोई एक काम कर रहा है और उसको एक नोटिस मिला है लोन रीपेमेंट का, ये नोटिस किसको माना जाएगा बेटा? मिला है आंसर, एक पार्टनर को मिला है, सिर्फ एक पार्टनर को एक नोटिस मिला है लोन रीपेमेंट का, और वो पार्टनर फाइनेंसेस देखता है. Will it be treated as a notice received by the firm? The firm's to yes. Okay, okay. गुड. आपको ये चीज समझ आ गई? तो यही तो ये सेक्शन कहता है. ठीक है, लेकिन एक बात कहती है, अनलेस द पार्टनर वाज इन्वॉल्वड इन अ फ्रॉडुलेंटली स्कीम रिलेटेड टू द लॉ. देखिए बच्चे, लॉ में ना एक जनरल लॉ ऑलवेज देयर, बट there is always an exception. If anything done fraudulently, the partner will be held responsible. You got my point? एक दूसरा एग्जांपल देख लेते हैं. अनुराग bought a bakery machine from Prerna which found to be stolen from Rishabh. Both partners are liable to original owner Rishabh except in case of fraud. Now what could be the case of fraud, or what could be other case? If Anurag, while buying the machine, bakery machine, is well aware of the fact that it is a stolen one. बेटा इसका मतलब ये हुआ कि जनरल लॉ में यदि आप फ्रॉड होता है, फ्रॉडुलेंट एक्टिविटी होती है, फ्रॉड प्रूफ होता है, तो अदरवाइज जनरल लॉ यही कहता है कि एक का किया हुआ एक्ट सभी का किया हुआ एक्ट माना जाएगा और फॉर्म बाइंड हो जाएगी. यू गॉट द पॉइंट? उसको ऊपर पढ़ने की जरूरत नहीं है बेटा. ठीक है, हमने विद द हेल्प ऑफ एग्जांपल पढ़ लिया. हमें सेक्शन याद होना चाहिए और अब सेक्शन कहता क्या है वो याद होना चाहिए. एंड आपको ये भी पता होना चाहिए व्हाइल आंसरिंग द क्वेश्चन इन द एग्जामिनेशन, फॉर एग्जांपल एग्जामिनर है आस्क्ड अ केस, फर्स्ट ऑफ ऑल you have to identify to which section it relates. Then you must write the section. What does the section says? What does the general law says? Then connected with the case law the examiner has asked. Then finally giving the conclusion that PQR is correct or ABC is correct, or agar penalized action is tenable or not tenable. So 3 steps are there to answer any case law. This is what the Board of Studies suggested answer has also followed this practice. आपका ICAI, आपका BOS के जो suggested answers जब आप देखेंगे, this is what the steps are while answering a case law. First of all, identify to which section the question relates. Write down the section. Tell the examiner what the section says. Then connected with the concerned question, and finally giving the conclusion that okay, PQR contention is completely wrong as per the provisions of the given act. Understood my point? How to answer? Is in the student case to not know that it is stolen only in Rag will be held? No, both are liable. गुड फेथ को मैं आपको बताता हूँ मीनू, देन इट कम्स अंडर लिटिगेशन एंड ऑल दैट. वो फिर केसेस हो जाते हैं और आपको प्रूफ करना पड़ता है कि हमने गुड फेथ में किया है. आई वाज नॉट अवेयर ऑफ दिस फैक्ट कि वो मेरा पार्टनर उसे चोरी करके लेकर आया है. देन इट बिकम्स द पार्ट ऑफ लिटिगेशन फर्दर. बट जनरल लॉज यही कहते हैं कि रिस्पॉन्सिबल होंगे. बेटा स्टेप्स आपको क्लियर हो गए एग्जाम में करने के ना? अभी हम आगे बढ़ते हैं. इस सेक्शन तक हम कवर कर चुके हैं. अब बारी आती है सेक्शन 25, 26 और 27 की. इसको यहीं से पढ़े बेटा. सेक्शन 25 says liability of a partner for the act of the firm. Sir, we have understood it a number of times. We have gone through so many slides and so many sections that liability of partner for the end of the firm is liability of the firm itself. What is new in this section? Section 26, liability of the firm for wrongful act of a partner. So partner will be held responsible for that wrongful act, obviously. Section 27, liability of a firm for misapplication by partners. Now the question arises, who will be held responsible, whether partner only or the firm? सर हमने यही पढ़ा है कि पार्टनर का किया गया कोई भी काम पूरी फर्म को बाइंड करता है ऑन टू प्रिंसिपल्स. एक तो आप कहते हो एक्टिंग बाय वन और ऑल ऑफ देम एक्टिंग फॉर ऑल, और एक कहता है म्यूचुअल एजेंसी. बट क्या ये हमेशा होगा? वी हैव टू लुक इनटू द नेचर ऑफ द बिजनेस, वी हैव टू लुक इनटू द एक्सेप्शंस. फिर सेक्शन 25, 26, 27 रोल में आएगा. अभी इसको पढ़ते हैं सेक्शन 25, 26, 27 क्या कहते हैं. एक एग्जांपल देख लेते हैं. If a partners enter into contract on behalf of the firm, all partners are jointly and severally liable to fulfill the obligation under the contract. So it is a very general law, and we all are aware since the beginning of this session. What is new? Beta, there is nothing new in this section. It is a general law which is known to all of us since the beginning of this session on 28th of March. So the section says about joint and several liability and scope of liability. Scope is very much important because in the time of litigation, the scope of liability is something which is to be looked into, whether the person to be held responsible or not. This liability extended to all the acts of the firm, meaning any action taken by a partner or the firm's agent that result in a right enforceable by or against the firm. यानी कि जनरली वो यही कहते हैं कि एक्शन टेकन बाय पार्टनर इज इक्वल टू बी एक्शन टेकन बाय द पार्टनरशिप फर्म. हमने एग्जांपल भी पढ़ लिया, जॉइंटली और सिवियरली लायबल. दिस इज व्हाट सेक्शन 25 सेज. सेक्शन 26 क्या कहते हैं? आपकी गलत करने पर आप कौन है? पार्टनर. इफ एनीथिंग डन बाय अ पार्टनर व्हिच इज रॉन्गफुल विल द फर्म हेल्ड रिस्पॉन्सिबल. सर हमने तो यही पढ़ा है कि पार्टनर कुछ भी करता है तो बेचारी फर्म रिस्पॉन्सिबल हो जाती है, यही पढ़ा आपने म्यूचुअल एजेंसी में. बट व्हाट इफ पार्टनर हैज डन समथिंग व्हिच इज wrongful act? Sir, what is the definition of wrongful act? Can anybody give me an example of wrongful act? पार्टनर तो कह के काम करके कह देगा it is not a wrongful act done for the benefit of partnership firm. Can you give me an example of wrongful act? How would you identify this is within the scope of implied authority or outside the scope of implied authority, or it is a tactic, or it is with a malified intention? Just give me an example. Defrauding a customer, correct. Theft of an asset beyond the power with the purpose to deceive the other. Malified intention, which causes loss to the firm. Fraud case, yes. आपको ये बात मालूम चल गई कि हर किया गया काम हमको बाइंड तो करते हैं विद एक्सेप्शंस. अभी पढ़ लेते हैं क्या कहते हैं. फर्म लायबल होगी टू द सेम एक्सटेंट एज द पार्टनर फॉर एनी लॉस और इंजरी कॉज्ड टू थर्ड पार्टी. देयर आर नो फ्यू की पॉइंट्स. फर्म्स लायबिलिटी टू सम एक्सटेंट फॉर एनी लॉस और इंजरी विच इज कॉज्ड टू थर्ड पार्टी. किसकी वजह से? बाय द wrongful act of a partner. If they are done by the partner while acting in the ordinary course of the business of the firm within the authority of the partners. If the act in question can be regarded as authorized and as falling with either of the categories mentioned in section 26, the fact that the method employed by the partner in doing it was unauthorized or wrongful would not affect the question. क्या मतलब हुआ? अभी पढ़ते हैं एग्जाम्पल से. All the partners in a firm are liable to third party for any loss or injury caused by the firm by the negligent act of a partner acting in the ordinary course of business. यानी कि अगर आप नेग्लिजेंस कर रहे हैं, wrongful act कर रहे हैं, तो आप liable होंगे. एक एग्जांपल देखते हैं. अनुराग and प्रेरणा left the bread making machine open due to which Rishabh got injured. अभी आपका क्या टेक है बच्चों इसमें? Who will be held responsible? फॉर्म को करेंगे या सिर्फ अनुराग एंड प्रेरणा को करेंगे, और ओनली इफ अनुराग इज इन्वॉल्वड इन दिस नेग्लिजेंस? देयर इज नो आंसर टू दिस क्वेश्चन इन माय स्लाइड. partners. Both partners or partner and firm both? Firm is liable for the act of Anurag. Excellent. But Dhruv, it involves the negligence on the part of partners. देखिए फॉर्म को आप बाइंड तो कर देते हैं, क्या फॉर्म आपकी हर नेग्लिजेंस के लिए रिस्पॉन्सिबल हो सकता है? It involves negligence. Negligence is a wrongful act. So partners will be held responsible rather than the partner who are at their negligence. बेटा ये ना कंफ्यूज करता है, अंडरस्टैंड कुछ चीजों में हमें कंफ्यूजन हो जाती है because we are not able to find a concrete answer then whether to hold the firm responsible or partners to be held responsible. See, firm is responsible. This is where the general law says. But when it comes to the wrongful act by a partner, when it comes to the negligence on the part of partner, you just cannot hold partnership firm responsible. It is your negligence. Okay, firm is liable for issue but can recover from Anurag and Prerna. No, only Anurag and Prerna will be responsible. Got the point? Now, what does section 27 says? Misapplication by partners. इसको भी एग्जांपल से देख लेते हैं. If a partner receive money from a client in the course of firm business and then misappropriates it, the firm is responsible for making good the loss to the client. लेकिन यहाँ पर दो स्टार्स लगे हुए हैं. क्या ये हमेशा ऐसे होगा? मुझे बता सकते हैं? Let me check the portal box if there is any query. No. बताएं बच्चे. Not always. Then misappropriation by partner है. Who will be held responsible? Firm is responsible for making the good loss to the client. However, the firm can recover the amount from that partner who has misapplied the asset of the firm. यानी कि फॉर्म लायबल है. ठीक है, आपके एक स्टडी मटेरियल का एक एग्जांपल मैं आपको पढ़ के बताता हूं, यहाँ पर जो दिया हुआ है. ठीक है, ABC are partners of a place of car parking. P stand his car in parking place, but A sold out the car to a stranger. For this liability, the firm is liable for the acts of क्योंकि misapplication और negligence both are involved in this case. Good to go. Now, what does section 29 says? Rights of transferee of a partner's interest. अभी क्या मुझे ये बताएं, क्या पार्टनर जैसे हमने कंपनी एक्ट में पढ़ लेते हैं, is partner entitled to share his part of the profit to some other partner? ये पॉसिबल है? पार्टनरशिप तो म्यूचुअल एजेंसी होती है, गुड फेथ में होती है, ट्रस्ट पे बिल्ड होती है, तो क्या आप अपना शेयर किसी को दे सकते हैं? Laboni, your answer is correct. Monu, no, your answer is not correct. If you have answered for this, transfer to other partners. Dhruv is correct. मीनू, आप कर सकते हो ट्रांसफर. ये बात हमने तब पढ़ी है जब हमने यूनिट 1 में सेशन 1 लगाया सबसे पहले 24 तारीख को, कि पार्टनरशिप फॉर्म में आप अपना इंटरेस्ट ट्रांसफर कर सकते हो, बट देयर आर नंबर ऑफ रिस्ट्रिक्शंस. वो मैनेजमेंट में टेक पार्ट नहीं करता, वो इंटरफेयर नहीं कर सकता. देयर आर नंबर ऑफ राइट्स व्हिच आर नॉट अवेलेबल टू दैट ट्रांसफरी. But yes, he is entitled to share of profit for that particular proportion for which the share of interest is being transferred to that particular person. Meenu, no and yes, both. How both could be the answer? No and yes. Okay, you remembered for that question. Okay, good. बेटा आगे देख लेते हैं हम. A share in the partnership firm is transferable. So the answer is yes, sir. It can be transferred like any other property. But as the partnership relationship is based on a mutual confidence, the assignee of a partner in trust by sale, mortgage, or otherwise cannot enjoy the same rights and privileges as the original partner. तो जब आपको ओरिजिनल पार्टनर के उसके प्रिविलेजेस और राइट नहीं मिलेंगे तो आपको मिलेगा क्या? व्हाट वुड यू गेट इन द कैपेसिटी ऑफ अ ट्रांसफरी? योर राइट्स विल बी ड्यूरिंग द कंटिन्यूएशन ऑफ पार्टनर द ट्रांसफर इज नॉट एंटाइटल्ड. देखिए राइट्स में क्या बता दिया, कुछ एक्सक्लूजन्स बता दी, ये आपके सेक्शन में ही लिखा गया है और दिस इज व्हाट द एग्जैक्ट कंटेंट इज इन दिस सेक्शन कि आप कंटिन्यूअस पार्टनरशिप में रह सकते हैं लेकिन क्या नहीं कर सकते, कंडक्ट ऑफ बिजनेस में इंटरफेयर नहीं करेंगे, अकाउंट्स नहीं लेंगे और ना ही उनको इंस्पेक्ट करेंगे. आपको ओरिजिनल पार्टनर के अधिकार, राइट्स और प्रिविलेजेस नहीं मिलेंगे. करेक्ट? Okay, now the next section is minors rights, minors duties, liability. Can minor be a partner in a firm? Just answer quickly. Few questions. Can minor be a partner in a partnership firm? Stuti, minor can be admitted to the profits of the firm. Hasini, yes. No, beta, your answer is not correct. माइनर कैन नॉट बी अ पार्टनर. बेटा पार्टनरशिप करने के लिए आपको करना क्या पड़ता है? अग्रीमेंट करना पड़ता है. एंड मुझे एक बात बताएं, अग्रीमेंट और अ कॉन्ट्रैक्ट विद माइनर इज मीनू कुमारी, नो ही कैन नॉट बी अ पार्टनर. To make somebody a partner, you have to make an agreement or contract with that person. Is contract with minor is valid? Void ab initio. विवेक शर्मा, आप लेट क्लास ज्वाइन करते हैं आई गेस. And I remember you because your answer is to the point always. What the law says, it is void ab initio. Beginning से ही गलत होता है. On he can be admitted only to the benefits of partnership. Oh. Okay, electricity problem. Okay. But always come up ready with your gadgets. The class schedule is always being told to you by the US. ठीक है, तो इसको ध्यान रखो. ठीक है, अभी कमिंग बैक टू द टॉपिक, क्योंकि आप बेनिफिट के लिए एडमिटेड हैं तो आपके कुछ अधिकार भी हैं और कुछ आपकी ड्यूटीज भी हैं. आप मेजर हो जाएंगे ऑन अटेनिंग द एज ऑफ मेजोरिटी, तब आपके क्या अधिकार होंगे या कब आपकी क्या ड्यूटीज होंगी उसके बारे में हम पढ़ेंगे. ये देखते हैं सेक्शन 30 क्या कहते हैं. You can clearly see in this picture, among all the partners, one is minor. Everybody is smiling and the minor is sad. Actually, he is not sad. उसको कुछ अधिकार नहीं मिल रहे हैं तो वो सैड है, लेकिन उसके पास बहुत सारे बेनिफिट्स हैं. बेनिफिट क्या है? वो लॉस शेयर करेगा? नहीं करेगा. क्या वो प्रॉफिट शेयर करेगा? वो करेगा. ठीक है, तो हमारे पास कुछ सिंपल क्वेश्चन है. सेक्शन 30 को मैंने सम अप कर रखा है. माइनर के आगे लिखा है कॉन्ट्रैक्ट विद माइनर इज वॉइड. फिर माइनर के आगे लिखा है देयरफॉर ही कैन नॉट बी पार्टनर इन द फर्म बट ही कैन बी एडमिटेड टू द बेनिफिट ऑफ पार्टनरशिप. अभी क्योंकि आपने उसको क्या, देखिए ये ना एक कंफ्यूजनल स्टेटस हो गई है हमारे. ही कैन नॉट बी अ पार्टनर बट ही कैन बी एडमिटेड टू द बेनिफिट ऑफ पार्टनरशिप फर्म. देन व्हाट इज द लीगल स्टेटस ऑफ माइनर इन टर्म्स ऑफ हिज लायबिलिटीज एंड राइट्स? उसके क्या अधिकार होंगे, उसकी क्या ड्यूटीज रहेंगी, ये हमें क्लियर करना है. और सेक्शन 30 इसके बारे में हमें बताता है. With the consent of partner only for the yes memo. आपके राइट्स देख लेते हैं. आप कौन है? माइनर है. अब माइनर पार्टनर हैज द राइट टू हिज अग्रीड शेयर ऑफ प्रॉफिट्स एंड ऑफ द फर्म, जितने पे आप अग्री करे हैं. ही हैव द एक्सेस टू इंस्पेक्ट एंड कॉपी द अकाउंट्स ऑफ द फर्म. He can sue the partners for accounts or for the payment of his share, but only when serving his connection with the firm and not otherwise. It means simply with the connection of business purposes only. On attaining majority, he may within 6 months elect to become a partner. He may. It is not a compulsion. You may not. You may choose not to be a partner after attaining majority. You may choose to become a partner on attaining majority. But within 6 months, elect to become a partner or not to become a partner. If he elects to become a partner, then he is entitled to share to which he was entitled as minor. यानी कि शेयर ऑफ प्रॉफिट कैसा रहने वाला है, सेम. If he does not elect to be to continue to as partner on attaining majority, then his share is not liable for any act of the firm after, read this line very carefully, after the date of public notice served to that effect. यानी कि माइनर लाइबल हो जाएगा यदि पब्लिक नोटिस सर्व नहीं किया जाएगा. यू गॉट द पॉइंट. ऐसी चीजें हम पढ़ चुके हैं पहले भी. यू अंडरस्टैंड. क्लियर दीज पॉइंट्स. इसको पढ़ना है बेटा हमने आगे. We come to know one thing, that minor can be admitted to the benefit of partnership forms to the agreed share. Now what happens if he attains maturity? At one option he can choose to become the partner. He could choose not to become the partner. What is the liability in both cases? In one case, obviously, if he becomes the partner, he chooses to become the partner, which he was not earlier because he was minor. But now he chooses to become the partner, he is liable to third party like all other partners. But if he chooses not to be the partner, he still remains liable unless or until public notice is served to that effect. सामने वाले को कैसे बताएंगे कि उसको क्या पता है 1819 हो गया. You understand? The third party is not supposed to know the age and when you are becoming a major. It is not the duty of or responsibility of third party. You must have to serve a public notice that I have attained the majority. Now I have chosen not to become the partner of the firm. So for that reason I am not liable. थर्ड पार्टी को ये बात क्लियर होनी चाहिए. अब इसको और अच्छे से समझते हैं. इसलिए अच्छे से समझेंगे क्योंकि आपके एग्जाम में कई बार सवाल पूछा जाता है. इसके 3 नंबर में 6 नंबर में कई बार पूछा गया है, तो आपको क्लियर होनी चाहिए. ये आपके राइट से, माइनर के अगर राइट है तो आपकी कुछ ना कुछ लाइबिलिटीज भी रहेगी. अभी तो आप आगे बढ़ रहे हैं, लाइबिलिटी में आपको पीछे जाना पड़ेगा. बिफोर अटेनिंग मेजोरिटी एंड आफ्टर अटेनिंग मेजोरिटी. देखिए जब आपकी मेजोरिटी हुई नहीं तो आपको लगता है कि सर हम मेजर एज में है ही नहीं, सब कुछ अच्छा अच्छा है, वी आर नॉट रिस्पॉन्सिबल फॉर एनीथिंग, तो लाइबिलिटीज भी कम होती हैं. देखा जाए तो सब अधिकार ही अधिकार होते हैं क्योंकि वी आर नॉट मेजर, वी आर माइनर. तो पहला पॉइंट क्या कहता है, लाइबिलिटी ऑफ द माइनर इज कन्फाइंड ओनली टू द एक्सटेंट ऑफ हिज शेयर इन द प्रॉफिट्स एंड द प्रॉपर्टी ऑफ द फर्म. बहुत ध्यान से अगला पॉइंट भी ध्यान से पढ़ो, कनेक्ट करते हैं दोनों को. माइनर हैज नो पर्सनल लाइबिलिटी फॉर द डेब्ट्स ऑफ द फर्म इंकर्ड ड्यूरिंग हिज माइनॉरिटी. जबकि बाकी पार्टनर लाइबल होते हैं डेब्ट के लिए. पहले पार्टनरशिप जॉइंट एसेट एस्टेट जाता है, फिर नहीं हुआ तो पर्सनल एस्टेट जाता है. माइनर के साथ ऐसा नहीं है. माइनर कैन नॉट बी डिक्लेयर्ड इंसॉल्वेंट, बट इफ द फर्म इज डिक्लेयर्ड इंसॉल्वेंट, हिज शेयर इन द फर्म, अगर फर्म इंसॉल्वेंट हो जाए तो उसका जो शेयर होता है ऑफिशियल रिसीवर या साइनी पे होता है, विच मींस माइनर कैन रिकवर हिज शेयर इन द फॉर्म ऑफ पोर्शन फ्रॉम द ऑफिशियल रिसीवर और साइनी. इट मींस माइनर के लिए सब कुछ प्रिविलेज ही प्रिविलेज है. ठीक है, बट दैट कम्स अंडर द पॉइंट ऑफ लाइबिलिटी. आप कहेंगे ना सर ये तो उसके राइट्स ही नजर आ रहे हैं, लॉ में ये लाइबिलिटीज के अंडर ही लिखा गया. ठीक है, क्योंकि फर्स्ट पॉइंट हमने लाइबिलिटी की बात करी है कि आपका केवल अपने शेयर ऑफ प्रॉफिट पे रहेगा. एक चीज मुझे और बताएं, क्या उसका पर्सनल एस्टेट रिस्पॉन्सिबल होगा रिकवरी करने के लिए फॉर द डेब्ट्स ऑफ द फर्म? क्या पर्सनल एस्टेट होगा? ऐसा क्वेश्चन हमारे को स्टडी मटेरियल्स में भी मिल जाएगा. नो. No, minor's personal estate won't be liable. Good. Where are rest of the students? Where are rest of the students? Minor's personal estate would be liable or not? हमने कॉन्ट्रैक्ट एक्ट में पढ़ा है कि माइनर का पर्सनल एस्टेट से रिकवरी होती है या नहीं होती कॉन्ट्रैक्ट एक्ट में? मोनो पर्सनल प्रॉपर्टी नॉट लाइबल. Good. Not liable. Understood. Now what happens attaining majority? सर आपने कहा था पब्लिक नोटिस जरूरी है, यदि पब्लिक नोटिस नहीं होता तो पर्सन जो कि पहले माइनर था आफ्टर अटेनिंग मेजोरिटी वुड बी हेल्ड लायबल टिल पब्लिक नोटिस नहीं दिया गया। देखिए हम दो बातें हैं बच्चे, मेजोरिटी या तो वो ही चूजेस कंटिन्यू टू बी विद पार्टनर, देन अगर वो, ध्यान से सुने बेटा, एक सिचुएशन है कि वो पार्टनर रहना कंटिन्यू करता है, इन दैट केस he will be held liable to third party retrospectively since the time when he was admitted to the benefits of partnership. It's a very important line. You understand this? There are two cases. One is he chooses to be continue as partner. He will be held responsible for the debts of the firm, liable towards the third party retrospectively since the time he admitted to the benefits of partnership form. Another case is he chooses not to be the partner. In that case, just answer me this. In that case, he will be held responsible. In which situation? Even the minor who has become major now chooses not to become partner, he still be held liable to third party. When? एक तरफ तो आपने पढ़ा वो पार्टनर चुनना कंटिन्यू करता है तो जाहिर सी बात है वो लायबल होगा थर्ड पार्टी को बिकॉज अब वो पार्टनर बन गया। दूसरी सिचुएशन में वो पार्टनर नहीं बनना चूज कर रहा है, स्टिल वो रिस्पॉन्सिबल है, ऐसा कब होगा? एक तरफ तो आप पार्टनर बनते हैं तो जाहिर सी बात है थर्ड पार्टी को लायबल होगी, आप तब भी लायबल हो जाते हैं जब आप पार्टनर बनना का चयन नहीं कर रहे, यू चूजेस नॉट टू बिकम द पार्टनर। यस, विवेक शर्मा always on point when he fails to give public notice in this regard. Laboni is on point until the public notice is served. The exact answer which I want. बस आपको आ गया फिर ये, अब इसको पढ़ लेते हैं क्या कहते हैं। विद इन 6 मंथ, अब देखिए समय भी दिया गया है, कानून में आपको समय दिया गया है, विद इन 6 months of attaining maturity or is obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, the minor has to decide whether he shall remain in partner or leave the firm. एक समय सीमा दी गई है जिसमें आपको डिसाइड करना। वेयर ही हैज इलेक्टेड, देखिए जब तो वो पार्टनर बनना को मान गया है तो आप मानते हो कि वो रिस्पॉन्सिबल है रेस्ट्रोस्पेक्टिवली, लेकिन अगर उसने पार्टनर नहीं बनना तो उसको पब्लिक नोटिस देना पड़ेगा that he has elected not to become a partner and such notice shall determine his position. उसकी पोजीशन बताएगा कि अब वो रिस्पॉन्सिबल है या नहीं है with regard to the firm. If he fails to give such notice, he shall become partner in the firm on the expiry of said 6 months. यानी कि आपको पब्लिक नोटिस कब देना है? एट द एज ऑफ अटेनिंग मेजॉरिटी, और देयर इज अ टाइम लिमिट विद इन 6 months ऑफ अटेनिंग मेजॉरिटी। पब्लिक नोटिस नहीं देते, यू विल बी हेल्ड कंटिन्यूअसली रिस्पॉन्सिबल। और यस, ऑटोमेटिकली आप नोटिस नहीं दे रहे, इफ द नोटिस इज नॉट गिवन इट इज अज्यूम्ड दैट ही इज पार्टनर। नो, यू नहीं नहीं मीनो, either you choose to become the partner or you choose not to become partner. One case you choose to become partner, you will be held responsible, you will be held liable to the third party. Another scenario is you chooses not to become partner, you don't become the partner because you chooses not to be, but you will be held liable to the third party till public notice is served. You understand the difference? Good. He does not become partner. जब आप पार्टनर बनना का चयन कर ही नहीं रहे हैं तो आप पार्टनर नहीं बनेंगे, लेकिन आप थर्ड पार्टी को लायबल जरूर रहेंगे जब तक आप पब्लिक नोटिस सर्व नहीं कर देते। Can we move further? Yes. एक बार इसको पढ़ लेते हैं. If the minor becomes partner on his own willingness or by his failure to give the public notice within the specified, his right and liability is given, he becomes personally liable to the third party for all the acts of the firm done since he was admitted to the benefit of partnership. His share in the property and the profit of the firm remains the same to which he was entitled as minor. ये बात हमने पढ़ी. जैसे आपका पहले शेयर था वही शेयर रहेगा. एक लाइन में इसके आगे लगाता हूँ unless otherwise agreed. तो इससे कहानी बदल जाती है. If I put a statement unless otherwise agreed, will it bring any change in the story? Yes, you know what changes will it bring? What could be the possibility that this could be the scenario or that could be the scenario? The share will change if the deed provides. So yes, simple. Stuti Goenka, correct. If any change in agreement, then we will go as per that agreement. His share of profit will be the same, which was earlier when he was a minor. Now the another is when he elects not to become a partner. Right and liabilities continue to be those of a minor up to the date of giving public notice. His share shall not be liable for any acts of the firm done after the date of the notice. After the date of notice, not before that. He shall be entitled to sue the partner for his share of profit. अब देखिए माइनर को कितना एडवांटेज है, वो sue भी कर देगा पार्टनर्स को अपने हिस्से के लिए. It may be noted that such minor shall give notice to the registrar that he has or has not become a partner. बेटा रजिस्ट्रार को नोटिस देना बड़ा जरूरी है. उसके पास आपके सारे वो होते हैं ना कि कौन पार्टनर्स है, तो आपको वहां पर नाम हटवाना और लगाना बड़ा जरूरी हो जाता है. नहीं नाम लोगे तो फिर उसके तो खाते में ही चलता ही रहेगा. ठीक है. Okay. Now it's the time for break for 5 minutes. Okay, we will resume the class. It is 12:06. We will resume the class at 12:11 or 12. Enjoy your break.
ECPL team, please announce break for 5 minutes.
Okay. So, students, section 31, introduction of a partner. Now, what does section 31 says? Subjected to the partnership agreement, the provision is subjected to any agreement between the partners, meaning the partnership deed may specify the rules for admitting a new partner. So there is a partnership form of 5 members. We have to include one another member, admit another member. What does the section says about the rules? And what is the liability of a new partner? Section 31(2) states that a person introduced as a partner does not become liable for any act of the firm done before they become a partner. It simply means when you are admitted to a partnership firm, you will be held responsible of the debts, the obligations towards the third party only after the date of joining the partnership firm, not prior to that. Another part is no dissolution by incoming and outgoing partners. The mere incoming and outgoing of partner does not cause a dissolution of firm subject to the contract to the contrary. It is a simple point. Got the point? Now, what could be the what would be the rules? What would be the rights? What would be the obligation of a new partner? How it will be decided? If a new partner is admitting into the partnership firm, what would be his rights and responsibilities? What would be his obligations? What would be his privileges? How it will be decided? Just answer me. Okay, start receiving answers. Into deed, yes, according to the terms and conditions of deed. That these are going to see, we have already understood that we may restrict a partner. You have read it earlier too. You may restrict a partner for the conduct of business. However, general law says you cannot restrict a partner to take part in the business of the firm. But there could be an agreement where the restrictions could be imposed there. So as per the deed. Now, what does section 32 says? Retirement of a partner. A partner may retire. How? With the consent of all other partners, in accordance with an express agreement by the partners, or where the partnership is at will. Will means there is no fixed time period for the partnership form. By giving notice in writing to all other partners of his intention to do so, to retire. A retiring partner may be discharged from any liability to any third party for the acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm. Such agreement may be implied by the course of dealing between the third party and the reconstituted firm after he had acknowledged to the retirement of that partner. It simply means partner may be discharged from his liability to third party for the act done which is before his retirement. But there must be an agreement to do so with that third party. Notwithstanding the retirement of a partner from a firm, he and other partner continue to be liable as partner to third party for any of the act done of any of them, which would have been an act of the firm if it is done before retirement. It simply means any act done before his retirement, he will continue to be responsible to the third party. Now, what happens after the retirement? Will the retiring partner still be held liable, still be responsible towards the third party? This we have covered in the previous class as well. Is retiring partner, let me change the slide, answer me. Is the retiring partner after the date of retirement free from all his obligation towards the third parties? Or he can still be responsible towards third party? Answer me. This we have covered in the last session as well. No answer received as such. No liable for further acts of the firm. I want the complete answer. Anyone? Old acts of the firm when he was a partner. Okay, this is, we have understood so far that he will be responsible for the acts of the firm when he was the partner. What after retirement? Does the retirement make him escape from all his obligations? No. I want the concrete answer, beta. No. No, you're not getting the point. Yes, Vivek Sharma. Always on point. And this time too, retiring partner is liable for any conduct done by him to the third party unless the public notice is given to this effect. He will be in, yes, Laboni Saha is correctly. So now you got the point. What is the importance of a public notice? You understand? Just read the last point. Notwithstanding the retirement of a partner from firm, he and other partners continue to be liable as partners to the third parties of any act done by any of them, which would have been an act of the firm if done before the retirement, until public notice is given to the retirement, provided that a retired partner is not liable to third party who deals with the firm without knowing that he was a partner. Got the point? Now, what does section 33 says? Expulsion. Can you, being the majority, expel any partner? There are few conditions where a partner can be expelled from the partnership form, provided the conditions are fulfilled. What is the conditions? Number one, the power of expulsion must be existed in the contract between the partners. It means there must be an agreement to this effect. Okay, sir, there is an agreement, so then we can expel a partner. No. Another one, power has been exercised by majority of the partner. Okay, sir, there is an agreement to this effect, to expulsion of a partner. Second one is, it is done with the majority of partner. With these two conditions cumulatively gives us right to expel the partner? No. The third condition, it must be exercised in good faith. Now, student, what is a good faith? It is a subjective thing. It depends upon situation to situation, circumstances, sometimes court interference in the cases, whether it is a good faith case or not. So it depends upon number of situations. But the general law says that if it is for the benefit of partnership firm, it is normally considered as in good faith. The expulsion must be in the interest of partnership firm, for the benefit of partnership firm. Sir, will that be constitute a good faith? Yes. Second point, the partner to be expelled is served with a notice. So the expelled partner must be giving a notice and opportunity of being heard. You just cannot expel a partner by, okay, don't come from this day onward. We being the majority expelling you. No. We being the majority, second point, with an agreement that already exists in relation to expulsion exists, sir, 2 points are there. Third one is, it is for the interest or benefit of partnership firm. The partner expelled has given an opportunity of being heard and he has been served with a notice. When these conditions cumulatively exist, then section 33 comes into play. Now the partnership firm can expel a partner. So these are very important conditions. You just cannot expel a partner with the help of consent of majority of partners. Other conditions are always to put into. Okay, start receiving few inquiries. Is liability public? Okay. Majority agreement in good faith towards the firm. Got this point. Okay. Yes. Okay, let's understand this case. If a partner is otherwise expelled, the expulsion is null and void. But this statement is in bold because examiner has asked this question in previous exams as well. We are going to cover this also. By the end of this session, we are going to cover the previous question papers as well. Let's understand an example which is from your study material. A, B, C are partners in a partnership firm. They were carrying their business successfully for the past several years. Spouse of A and B fought in ladies club on their personal issues and A's wife was hurt badly. A got angry on the incident that he convinced C to expel B from the partnership firm. B was expelled from partnership without any notice from A to C. considering the provision of Indian Partnership Act 1932, state whether they can expel a partner from the firm or not. The answer is not given over here. You answer me. As per the section 33, is the expulsion of the partner is valid, is tenable or not? It is a question which is given in your study material. But how will you answer a question? Just write it down the steps which I have already told you. Stuti says it is due to personal grudges, not in the interest of the firm. Very correct answer. Okay, just recall, just give a recall to the steps which I have told you how to answer. This is a question from your study material. Just imagine this is a question asked in your exam. What would be the sequence of answering this question? I want a concrete answer for this. What would be the sequence to answer this? The Board of Studies suggested answer has given a particular set to be followed. Okay, first of all, provision, fact of the case and conclusion. Chinmay, okay. Provisions, yes. Fact of the case and conclusion, analysis and conclusion. As per section, this power of expulsion must be an agreement. Okay, so you got the point. Yes, as per section 33 of India, they cannot expel because it is not an agreement. No, beta, Laboni Saha, again, you're not understanding the point. You have mentioned the section and then you jump onto the conclusion. First, you have to tell the section and what does it says. Then relate it with the case study. Then finally give the conclusion. You have mentioned the section, then you jump onto the conclusion. No, there are 3 points. Beta, your suggested answers by Board of Studies has these steps. First one is to relate it with the section, explain the law. Second one is related with the case study. Third one is giving conclusion. So all of you are not aware now that the expulsion is null and void because it is not as per the conditions. What are those conditions? Is the expulsion is in good faith? No, sir. Is the expulsion for the benefit of partnership firm? No, sir. You understand these points which we have covered? These things. We are not going further than whether the expelled partner is given an opportunity of being heard or served with the notice or not. We just, given information, we come to know that the expulsion is not in the good faith, not in the interest of benefit of partnership firm. So effect is cumulative. So we just cannot expel a partner on the personal grudges. It must be for the benefit of partnership firm. Got the point? Now section 35, liability of a state of deceased partner. Now what happens when a partner dies? What happens with his estate? What are his rights and what are his liabilities? Let's understand it with an example. If a partnership agreement allows the business to continue even after the partner's death, so we have understood that on the death of a partner, there brings a change in the constitution of the firm and the partnership firm get dissolved. But again, subjected to the contrary. If the agreement allows the business to continue even after the partner's death, we can go that way. The deceased partner estate would not be liable for any debts or obligation incurred by the firm after their passing. Another example, Anurag was a partner in a firm. The firm ordered goods in Anurag's lifetime, but the delivery of the good was made after Anurag's death. In such case, Anurag estate would not be liable for the debt. A creditor can have only a personal decree against the surviving partners and a decree against the partnership assets. Now there comes a story where liability towards third party will lie on the remaining partners, not on Anurag. The liability lie on the surviving partner and against the partnership assets, not the assets of a deceased partner. You got the point? What does section 35 says? Hence we cannot. Okay, Prakriti, we have done for this question. Is this point clear? Section 35 clear to all of you? Aminu once again, okay. See, when a partner died, the remaining partners and the partnership estate will be held liable for the third party. This is what simply the point says, section 35 says. Okay. Okay, section 36, rights of outgoing partners to carry on competing business. So far, we have done Indian Contract Act 1872 as well, where it states restraint in trade is void, but with some exceptions. Restraint in trade is void, but with some exceptions. That role comes into play here also. Can an outgoing partner engage in competing business? Beta batao. It's student task. Let me change the slide. Students, dear student, please answer. Can an outgoing partner engage himself in a competing business or not? Stuti Goenka, no, he should not, is not an answer. We just cannot answer a law in should. Because the ethics are not there, the morals are not there with it. A particular condition does not fall in the category of should or should not. So, no in case of death with the private estate, carrying on business duty. So you are restricting him to carry on any trade? No. So because you are restricting him. Is restraint of trade is valid? Stuti, if you are restraining him for doing a competing business, simply you are restraining him to trade, and restraining anybody to carry a livelihood is fundamentally constitutionally wrong. Forget about what Indian Contract Act says. Forget about what Partnership Act says. It is fundamentally, and under the Indian Constitution, it is wrong. You just cannot restrict anybody to make a livelihood. And if it comes in the Contract Act, if it comes under a Partnership Act, you just cannot restrain anybody to come to carry on a business. But definitely there are few exceptions. What are these few exceptions? Yes, but there is yes. Section 27. Normally it is no written deed. Okay. Let's student ask. Can he engage in competing business? Yes. But he may not, provided use the firm name, represent himself as carrying on the business of the firm, solicit the custom of person who were dealing with the firm before he ceased to be a partner. It simply means you just cannot take the benefits of previous partnership to carry on your competing business. You just cannot use the name, logo, your suppliers, your connections, solicit the customs of persons who deal with the firm. So the conclusion is section 36 says yes, you can you can do the competing business provided these conditions are fulfilled. You got the point? Section 36 is deep. Now the role of section 37. Right of outgoing partner in certain cases to share subsequent profit. Now there is big story in this slide. Let's not get into this big story. Let's understand it with the help of an example. With the help of this example, you will automatically come to know what section 37 says. So can we move further? For example, Anurag, Prerna and Rishabh are partners in a textile firm. Everything is going great. Anurag is entitled to 1/3 share of the partnership property and profits. Now Anurag becomes bankrupt, whereas Prerna and Rishabh continue with the business without paying out Anurag's share of partnership assets or settling the account with his estate. Anurag's estate is entitled to 1/3 share of the profits made in the business from the date of his bankruptcy until the final liquidation of partnership of agents. What do you understand with the help of this example? The section 37 says, what are your rights if you are an outgoing partner? Like in this case, Anurag is an outgoing partner. What are his rights? Just tell me. Anurag estate is entitled to 1/3 share of the profits made in the business from the date of his bankruptcy to the final liquidation of the partnership of agents. You understand how the section defines and explains the right of an outgoing partner. Just reading to this, any member of the firm has died or ceases to be the partner, the surviving partners or continuing partner carrying on the business of the firm with the property of the firm without any final settlement of account as between them and the outgoing partner or his estate, then in the absence of contracted to the contrary, what does the general law says? It says the outgoing partner or his estate is entitled. It means it talks about the right of an outgoing partner at the option of himself or his representative to such share of profits made. It means you are an outgoing partner. In the capacity of an outgoing partner, you have certain rights. What rights are the section talking about? It is talking about the share of profit made since he ceased to be the partner, as may be attributable to the use of his share of property of the firm or at the interest at the rate of 6% per annum on the amount of his share in the property of the firm. This could be asked in the study material of ICAI in MCQs. What is the rate per annum for the share of interest of an outgoing partner? Provided that whereby contract between the partners, an option is given to surviving or continuing partner to purchase the interest of a deceased partner or an outgoing partner, then at the option is duly exercised, the estate of deceased partner or the outgoing partner or his estate, as the case may be, is not entitled to any further share of profits. Why? So you have been telling us that the outgoing partner has the right of share and at this particular percentage in the property of the firm. Now you are saying, sir, he does not have any, he is not entitled to any further share of profit. Why? What is the difference between these two points? Can anybody tell me? Earlier, I have told you that outgoing partner has the right, which is defined in section 37, to his share of profit in the property of the firm, and the rate has already been mentioned over there. Now I'm saying that the outgoing partner, the deceased partner or the outgoing partner is not entitled to further share of profits. Why? What is the difference? Anybody? Read the line carefully again. Start receiving answers. It says his account was not settled by the firm. No. Anybody else? Because he transferred share of partner to another partner. Yes, monosyn. The correct answer is there. See, read the line again. Provided that whereby contract between the partner and option is given to surviving partner or continuing partner to purchase the interest of deceased partner. When you have sold your interest, how it will become your right now? You have sold your interest to the surviving partners. Now you, on your own will, leaving your rights to the further share in the property of the firm. So it has been clear that if you have not sold your interest to the surviving partners, you will be entitled to the share in the property of the firm till the time the account is settled or the liquidation settled. But if the surviving partner purchase the interest of deceased or outgoing partners, that deceased or outgoing partner is not entitled to any further or other share of profit. Example we have done already. Now section 38, revocation of continuing guarantee by change in the firm. Now, there may be the case that the guarantee has been given while doing the partnership business. There are a lot of cases where the guarantee has been passing on from one person to the another. What happens if there brings any change in the firm? So, what does the change in the firm means? What does the change in the firm means? Retirement, death, incoming, outgoing, change in the fundamental nature of the business. All these constitute the change in the firm. So, what happens of continuing guarantee? A continuing guarantee given to a firm or to a third party in respect of a transaction of the firm is in the absence of any agreement to the contrary, revoked, radd ho jati hai, it get cancelled as to future transactions from the date of any changes in the constitution of the firm. It simply means at a point of time when the constitution of the firm change by reason of say dissolution, by reason of admission, retirement, or change in the nature, the continuing guarantee gets revoked for any of the transaction of the date after the change in constitution of the firm. You got this point? For example, today is the change in the constitution of the firm. After the expiry of this date, any future transaction with relate to any future transaction, the guarantee will not be held valid. You got this point? Anybody? As change in the firm, guarantee will get revoked. Hasini, partnership at will. What does partnership at will means? See, if there is an incoming partner or retirement partner, it will result into the change in the constitution of firm. For future transaction, the guarantee will get revoked. Got the point? Moving further, there are a few questions. Now, beta, all of you, please be careful while answering the question. Explain the status of minor in terms of rights and liabilities in a partnership form. First of all, what is the sequence of? I'm not saying that you have to answer it right now because you're just going through this session. So, getting the concrete answer, I'm not expecting from each one of you. Just tell me the sequence. How would you answer it? Please sequence, or what could be the practice that follows in a suggestive answer. Hurry up. Beta, you don't have to write the answers. Just give me the sequence. Just give sections will be identified, then provision and status. Okay. Identify section mention this inverted situation answer case case study. Yes. See, in this question, you don't have to bring on to the conclusion because it is not something to ask about the particular case law. So conclusion is not required. See, there is no case law involved. So just tell the sections what the section says about the rights and liabilities in a partnership form. That he can access to the benefits of partnership form. He can access to books. He can inspect the books as well. His share of rights in partnership property. That's it. And liabilities. Liabilities may we have understood that there is only one liability. Other rest are only privileges given to the minor. If you want to see one, there are the rights, there are the liabilities before attaining majority, after attaining majority. Okay? He chooses to be the partner, he chooses not to be the partner, within the time period, public notice should be there, and all things. Short notes on section 33. Now, institute usually don't ask this type of question where only section has been mentioned here. But I have put this question without naming what the section belongs to. Now tell me what the section 33 belongs to. Okay, expulsion. Great. Expulsion. It must be in good faith. There is an agreement to that. It must be for the benefit of partnership firm. The expelled partner must be given a notice, and expelled partner must be given an opportunity of being heard. Liability of a state of disease partner we have recently covered. Right to remuneration we have covered in the previous session. You remember right to remuneration? Is every partner is entitled to share of remuneration in the partnership firm or not? Answer C part, right to remuneration. No. Yes, Tuti Goenka has correctly answered. Is it the case always? No. Only if there is an agreement. So it's good to know that the students are well aware of the previous sessions as well. Unless provided by the deed or customary. Yes, Anurag, or customary. No, it's not unless provided. Unless provided by the agreement, or it is in the usual custom of the trade. Two conditions are there, beta. If there is an agreement, or if it is usual course of business to provide remuneration, custom and date. Great, good to go. The question is, Rag and Prerna, two partner in Basu Paper Mill, after 3 months of doing business, they admitted Rishabh as their partner. After working for 1 year, Rishabh found to be made some purchases from a supplier and found to be, number 1, unauthorized purchases. Number 2, made personal benefit out of the purchases. Now, 2 are different cases altogether. Explain in both cases the remedy available to Prerna and Anurag, keeping in view the provisions of Indian Partnership Act 1932. Now, student, there are 2 different cases. Just tell me, answer would be the same or different? First, understand the case. If he made unauthorized purchases, who will be held responsible? Answer for the case 1, if he made, Rishabh made unauthorized purchases. Not receiving any answer, where are you? Okay. Then I have to tell the answer. If Rishabh has made unauthorized purchases, the firm will be held responsible for those purchases, even if it is unauthorized. But is this the case always be there? Okay, start receiving the answers. Custom, both cases, Rishabh is liable. The firm will be held responsible. The firm will be held liable. However, he has to make the loss good to the firm because he has done something which is not in his authority. Not always, correct. Now, in other cases, made personal benefit out of the purchases. See, in first case, firm will be held liable. Why? Because no doubt he has made a purchases which are unauthorized. Still, firm will be held responsible. And in case 2, Rishabh has made personal benefit out of the purchases. What will happen in that case? Case 2, Rishabh is liable to reimburse the firm for the benefit. Yes. Laboni Saha correctly answered. Rishabh is liable to reimburse the firm. It means he is liable to make the loss good to the firm because something, injury, some loss, financial loss has occurred because of his misconduct, because of his doing of business which is not in his authority. Meenu Kumari, you have answered for case 1 or 2. Okay, let me make a twist in this case. What if the supplier? Listen carefully. It is not mentioned over in this slide. What if the supplier is well aware of the fact that Rishabh is doing something which is not in his authority. I'm just adding a twist in the case law. What if the supplier is aware that Rishabh is doing something, while dealing with Rishabh, he is doing something which is not in his authority? Only Rishabh will be held to supplier in such case and not the firm. Yes. Laboni Saha, correct answer. Then firm is not liable. This question, match the following. Okay, we are not going to match the following. We will start explaining everything. Partner commits fraud in the conduct of business of the firm. To which point it relates? Partner who is committing a fraud in the conduct of business of the firm. Point 2, correct. He shall indemnify the firm for any loss caused by fraud. Then minor's liability, limited to his share of profit only. See, we have done so far that minor has rights, minor has liability. But among all the rights and liability, there is only one liability for which minor is held liable. That is limited to his share of profit only. This is basically a privileged. Implied authority of a partner. What does implied authority means? There are few exclusions specifically mentioned there. The partner could not do this, and there are few cases that partners could do this in the implied authority, and rest of all the functions are considered within the scope of implied authority, other than those which have specifically excluded. Like he cannot make a suit against anybody in the name of the firm. He just cannot admit a liability in the name of the firm. Those are exclusions. From which particular point the C points belongs to? To start receiving answers is 0.2. An act of intention to the third party, sir, C3, correct. Then obviously B belongs to 1. The share, transfer of share in a partnership firm by one partner to any third party to receive the share of profits of the transferring partner as agreed by the partners. Now question number 2. Which of the following statement or statements is or false? A new partner can be admitted with the consent of majority of the partners. Right to receive remuneration is not the default right of the partners. Partners are bound to carry on the business of the firm to the greatest individual benefit. बताएं. No. Okay, just answer me one thing. Forget about which option is correct. Just tell me, can a new partner be added with the consent of majority of partners or with the consent of all the partners? Just make this difference clear. Just answer me. Can a new partner be admitted with the consent of all the partners or with the consent of majority of partners? But you must be clear about this thing. All the partners unless provided in the deed. So basically it is with the consent of all or majority. Yes, all. First statement is true? No. Right to receive remuneration is not the default right of partners. Okay, fine. Just tell me, is right to receive remuneration is the default right of partner? It is the right of partner. Receiving remuneration is the right of partner or not? No. Then when it becomes the right of partner? If it is as per the deed, if it is as per the custom. Yes. Statement 2 is correct or not? So the intention of the question is not to answer a particular option. The intention of putting this question is to understand each statement What does the Partnership Act, the provision of Partnership Act says about this particular statement? Right to remuneration is not the default right of partner. It is basically not there. Partners can get remuneration only if it is custom, it is usage of trade, and only if it is provided in the agreement. So that statement 2 is not correct. Partners are bound to carry on the business of the firm to the greatest individual benefit. It is very prima facie wrong statement because it is for the benefit of the entire firm, not the benefit of individual partner. Forget about which option the question belongs to, which the intention of the question is fulfilled. We come to know every statement. What does the law brings for each and every statement written over here? Moving on to the next question, just answer this question. We have just recently read it. How much rate of interest? Everybody's okay, 6, good. Minu, Monu, Vivek Sharma, this time you are wrong. Beta, for the very first time you are wrong. No, beta, it is 6% per annum. Please understand the significance of 6% per annum or 6%. The answer is none. The time duration, whether it is half yearly, quarterly, is not mentioned over there. Please understand. The answer is none. It is 6% per annum. Vivek Sharma, this time you are wrong. But good, you. Okay, OMG. Okay, fine. Unanimous consent for all the partners required for permission for transfer of partner of his interest in the firm, fundamental change in the nature of firm, or all of the above. The answer is very clear. Yes, all of the above. See, my intention to put question number 3 without rating per annum was to check the carefulness of your being attentive in the class. Moving on to the next question, insolvency of the partner कहाँ पर है? Section 34 में. कुछ previous year के question बेटा फटाफट कर लेते हैं. ठीक है, let's come to the first question. A minor admitted to the benefit of partnership firm is entitled to certain rights and may also have certain liabilities. You just have to say 6 marks question. Liabilities and rights of a minor before attaining majority only. So we know right to share of profit, right to have books of accounts, right to inspect the books of account, share in partnership property to the extent of his share only, and liability. The last point is the liability of the minor before attaining the majority. You got this point? Let us see the question that has been asked in the previous exam, constituting 6 marks. Will you be able to answer this question? I'm not saying that you must be given concrete answer right now, because obviously you will have to make 2 to 3 times revision and spec copies for profit. Yes, question is clear. It should not be the case that the question goes over your head, sir, what has been asked in the exams, and we are totally blank. Cover this in our syllabus. So, and we are able to answer this question asked by the institute. Moving on to the next question. PQR a partner in a construction firm. PQR associates. P buys cement on behalf of firm from D. The cement is used in the ordinary course of the firm's business. P uses the cement for personal purposes. The supplier D, who is unaware of the private use of cement by P, claims a price from the firm. Firm refuses to pay the price because they say that D has done something which is for his personal purpose only. Now the question arises whether the firm's contention is tenable or not. Whether the firm's condition is tenable or not. Let me check the portal box as well. Is there any question been asked? Okay. Okay, so once again. Terms condition is tenable or not? Okay, beta. So this will be your homework. You'll have to find out the answer for both the case for 1 and 2. Can I expect the homework that will be completed by the next session? 30 of them. Okay. See, beta, this will be your homework. You must have to do this before the start of the next session. That is on 4th of April. You have the entire day, 2 days actually. So this will be your homework. With the start of the next session, first I will be covering this question. This will be your homework. Just have a look on the last question. Referring to the provision of Indian Partnership Act 1932, answer the following question. If a partner is otherwise expelled, now this otherwise has a very great significance. The expulsion is null and void. Discuss. Partner can be expelled if there is an agreement to do so, if it is in good faith, if it is in the interest of partnership firm, the partner must be given an opportunity of being heard, the partner must be giving notice to the. If these conditions are cumulatively exist, then the expulsion is okay. Otherwise, the expulsion is null and void. We have done the case study from the study material as well. The question where there was a fight in the club. Remember? That was a question from your study material. Able to answer 4 marks question? Last question. The partner who is expelled will cease to be liable to third party from the act of the firm done after expulsion. Analyze. Just answer this question. Cease to be liable to the third party after the expulsion. Okay, say, can I expect this question in homework as well? Or do you want me to write it to answer it right now? Can I expect this question in homework as well? Beta, these are very important questions. Sometimes the similar kind of exact questions are asked by the institute in the coming exams as well. Okay, Labonis, I say that I can expect. So now you have homework for the previous question and for this question as well, for the second part only. Before starting the next session for dissolution of partnership firm, we will be covering these questions because I want answers from you people. Okay. So we have for this class. I hope everything is being clear to you, and if there is anything left, you people have time to go through the PPT, to go through the study material, to go through the books, understand the concept, remember, recall the sections, and don't forget the sequence to answer any question. Too hard if it's not okay. Remember these points for not only for this exam, for the rest of your exams also, for other subjects as well. So eager to meet you for the next session. So far we have done. Megha ma'am.
Yes, sir. Yes, sir.
I'm done
Thank
with
you,
today's
sir.
session. Ji.
Yes, sir. So thank you so much for the wonderful session today. Dear students, we have completed Unit 2 of Chapter 4, that is your Indian Partnership Act 1932 today. We have seen all the sections in detail here and many examples we have seen. And sir has also discussed some descriptive questions and MCQ questions as well. And 2 questions he has given you for your homework. So we will discuss the same questions on Friday. And now you can do one thing, that you just read this Unit 2 from the study material. The entire chapter you have to read from the study material. Also, just go through the Saransh. All the students must be aware, we have discussed this many times, that Saransh is the publication where we have We have given the study material in the form of a short notes or pictorial flowchart, pictorial picture presentation. So this is the compilation of around 200 pages. Saransh is there. It's available on the website as well as CDS portal. So just complete this chapter from the study material and as well as from the Saransh. So then double revision will be there. Okay. And after that, we have recently introduced the MTP booklet. I have discussed it in the earlier session as well, that we have given the MTP booklet, which comprises of 10 MTPs of past MTPs along with their answers. So this compilation is of around 250 questions and answers. So just finishing this chapter from the study material, the MTP booklet as well as the RTP. Because the RTP we have given the questions the chapter wise. So you have completed 4 chapters, 3 is left from the chapter 4. So you can do all the questions and answers from your respective RTP. And after finishing our classes on 16th April, we are announcing, we are conducting webinars. The schedule will be uploaded in a day or 2 days. And MTP Series 1 as well as Series 2 will be started in April and in May. So just finish your syllabus, just finish these classes as well as revise from the study material and Saransh and MTP booklet and RTP, and after that, be ready for your MTP Series 1 and MTP Series 2. Okay, so in the April, we will have these quiz of MTP, and second series we will have in May, as well as we have a session with us. VS for your session. Common query I received, one common query many haven't by the answer, but one query sir has also tried to resolve, but how to present the answers. Sir has also emphasized that you have to present your answer. There are 2 types of questions. One is descriptive and second is application oriented. Okay, so these type of queries we are taking in our classes daily, but today also I received the same query from 2 3 students, that how to answer the application oriented questions. Dear students, for this question, you have to write you have to write the legal provision first. Okay, sir has also explained this point well, that for the case study questions, first write the legal provision. Many students ask us that whether to write the legal provision is mandate. Yes, students in the examinations, step marking here. So you have to write the legal provision first. Then you can, in very brief manner, tell the uh, Question in brief you can discuss, and at the end you can correlate the legal provision with your question and conclude your answer. Okay, you can see the multiple type of questions, these type of questions in your RTP, in your MP booklet. When you will do the written practice of these questions, this problem will be solved. Okay, so just read the unit 2 today itself, complete it, and try to read unit 3 as well before coming for the session to be conducted on Friday. Okay, dear students, thank you so much. Yes, technical team